Okay, I think we are ready to get started. Good morning, everybody. Thank you so much for being here with me today. I'm Erin Owens. I'm a professor in the Newton Gresham Library at Sam Houston State. Um, as the scholarly communications librarian, I support uh, people on campus, students, faculty, everyone, on a variety of topics related to conducting and then publishing or otherwise disseminating original research. Today's session is a brand new one. You get to see this for the first time. So it may still be a little bit of a work in progress, but I am really, really excited to be talking about this today. We are going to be talking about journal publishing agreements and kind of understanding how to read them and what to look for before we actually sign them as legal contracts. All right, so let's go ahead and dive right in. A little bit of a roadmap for our presentation. We're going to talk about what a publishing agreement is, what it does it do, how do we read it, what does it mean for us, can we negotiate it, can we refuse it, what sort of flexibility do we have, and then that's kind of thinking about contracts that we're signing now for things to be published in the future, right? But then I also want to take one step back and think about things we may have published in the past when we didn't necessarily know what we signed in the agreement and talk about what we can do with that content, how we can share it. And then we'll wrap up with some resources. I will share the slides and the recording afterwards. All right, so what is it? Regardless of the publishers using terms like an agreement, a publishing agreement is a legal contract. And I think that's really important for us all to know when we're going into it. It is a legally binding contract. Essentially, it's going to specify what rights you are giving to the journal to use your writing. It's also going to specify what rights you keep or what benefits you receive if there are any. We don't usually get a, paycheck for it or anything, but they may throw in something. Um, I think what we see is that it's often not treated very seriously, especially by early career researchers. I definitely can say for my first couple of publications, I wasn't reading these things very closely. I wasn't thinking about it. It felt like this is just the last hurdle that I have to get over to see my paper in print. I felt a lot of pressure to just sign it, send it in quickly, make it happen, and then be able to say that I crossed that finish line. But like any contract that we're signing in any part of our life, we do need to think about reading the fine print and knowing what am I signing? What am I agreeing to? Now, because these are legal contracts I'm talking about, I'm going to give you a quick caveat that I am not a lawyer. This presentation does not constitute legal advice. I'm going to do my best to summarize and interpret what I understand from some examples of publishing contracts, but I'm not going to give you any advice on what terms you should or shouldn't accept in a contract, nothing like that. That's going to be up to you to decide what you're comfortable with. And if you have concerns about a specific contract for specific reasons, I definitely encourage you to seek legal counsel on that. Okay, so how do we read our publishing agreement? Carefully. That's the bottom line. Some of them do better than others. Some publishers really try to break it down into more readable language, but it can sometimes get very heavy on that legalese, legal jargon that makes it a bit more challenging to parse. Um, One thing I think is important is don't assume anything that's not explicitly stated. You may think, oh, well, they don't say that they're going to take away my right to do something, so I'm assuming I keep it. But if it's not explicitly stated, then you really want to kind of verify and ask questions because ultimately, in legal contracts, if it's not there in black and white, it probably doesn't exist. Definitely send questions to the publisher. Um, they may try to rush you along in terms of how quickly they want you to sign it and send it back, but don't fall prey to that pressure. Take the time. If you have a question, send them the question and get it answered before you sign it, and then kind of re-emphasizing to seek legal counsel for serious concerns. So what sorts of things are we going to find in here? And we are going to look at some examples in just a moment, but The contracts are going to have a lot of definitions. They are going to define what they mean by every special term because some words have really special meanings in law. They're going to define the parties involved. What term are we going to use in here that refers to you as the author? What term are we using that refers to the journal or the publisher or making sure you understand who's who? They're going to specify things that you affirm to be true about your research conduct as well as your article. And we'll look at some examples of this. But part of what you are agreeing to in that contract is I confirm that I have, behaved ethically, that I have followed all of these laws and complied with this and that I read the journal's policies on these things and understand them and agree to them. So there's a lot of things that may kind of be under your radar that aren't about the piece of writing as a literal object, but that are more about your behavior as a researcher and author. That it's like, oh, well, you signed this contract that said you did these things. So then if somehow later you didn't actually do one of these small things that was listed in here, that could come back to bite you. Definitely the contract is going to specify what rights you are giving up to the publisher. That could be saying that you sign over your entire copyright. It could be saying, like, literally, I don't own this work anymore. I don't have any rights to it anymore. I'm giving everything to the publisher. Or it could be a little bit more granular. I give the publisher permission to do XYZ. Maybe I allow them to be the only person who can do X, but then other entities could also do Y and Z. So it may be very, very global or it may be very granular. That's going to vary just by the publisher. What rights you retain. Even when you sign over your absolute entire copyright and you don't own anything anymore, they will usually let you retain a few specific things. How generous or how specific they are varies by the publisher, but at a bare minimum, they'll tell you things like, oh, well, you can still give out copies of your own paper to your colleagues as long as you're not making money off of it. They may get really, really nitty gritty, but they'll give you some kind of privileges to using your work. As with many contracts, another thing we will often see in here are agreements about who bears liability for anything that goes wrong. So if you give them your copyright and then they face some kind of a lawsuit because of something you did wrong in the research, maybe, they're going to have you agree that you will bear liability for that. If it costs them something monetarily, that you'll be responsible. Definitely, we want to know if they're going to hold us to something like that. And then they'll often talk about how any disputes will be handled. Um, Disputes could go to court through normal court proceedings, or they might mandate that they go through mediation and that you have to work with mediators rather than lawyers and judges. So they'll give you usually address some kind of details about that. If we come to a disagreement, how will we resolve that? Okay. One really key, crucial term to know as we read our publishing agreement is the term exclusive. What we mean by this in our publishing contracts, if someone has an exclusive right, according to this contract, it means they are the only person or party who has permission to do this thing. No one else can, the only way that anyone else can be given permission is by asking that person who has the exclusive right. So if I sign over to the publisher the exclusive right to publish my article, then I can't ever give anybody else the right to publish it in some other format. If somebody else wants to reprint it, they will have to go through the publisher. Anyone in the contract who is said to have a non-exclusive right means they have permission to do the thing, but other parties can also get permission. So if I give them non-exclusive permission to publish, then they can publish it, but I can also allow other people to publish it in other contexts and other formats. So you're going to see exclusive and non-exclusive come up a lot as we go through these examples. All right, so let's go ahead and dive into those because I think this is where the really nitty-gritty fun stuff comes in. I'm going to look at several different publishers. So the fact that I start with Elsevier doesn't mean I'm picking on them in particular. the Elsevier transfer of copyright, and you'll get links to all of this. For purposes of presentation, it was easier for me to kind of copy and paste excerpts, but I have given you links to where you can see the full sample agreement and all of this publisher's policies just for greater context. So, in the Elsevier transfer of copyright, first there are some warranties made by the author. These are the things you affirm to be true. Most contracts have these basic stuff. Elsevier addresses all these basics. These are going to be real common. You know, you confirm that the paper is original and yours. You haven't published it or licensed it before. You're not violating anyone else's rights. You're not committing any kind of libel or slander. You've accounted for copyright permissions, like if you've reprinted someone else's figure, you've addressed having permission for that. If your work involves human subjects, you've accounted for informed consent, which most of us, we'd have to go through an IRB approval anyway. We would have dealt with that, but they want us to reaffirm that that's been done. We affirm that we have researched ethically, that all the authors of the paper are listed on the paper appropriately. We haven't left anybody off, and all of them have approved this publication. And then we've acknowledged any funding sources as necessary and disclosed any competing interests. This is really the core of stuff that very basic to see in any publishing agreement. Now, Elsevier adds a few additional pieces in by them on their own. They want each author to confirm that they are not identified as a specially designated national. I'm not even immediately sure what a specially designated national is. So I don't think I'm one, but like I would want to go look up a definition of what they even mean by that. Then they ask you to affirm that, and if any of the authors reside in these specific countries, the article has been prepared in a personal capacity, not in any way on behalf of the government of that country. Okay, does that affect an enormous percentage of their articles? Probably not. But for the small percentage who may have an author in one of those countries, like they need to know that this is in there. They need to know that they're agreeing to this and that they could then be held legally responsible if this is not entirely truthful, if this research was in some way involving the government. And then finally, this one just makes me laugh. They want you to affirm that if you have included any software in like the supplemental materials or the research data for your paper, if you've included any software, you guarantee us that it is free from viruses, contaminants, and worms. It's certainly going to be free of them as far as I know. I just hope that there's not one there I didn't know about, right? But that one is that seems to be a very uniquely Elsevier thing to have included here. So that's the first section. This is all the stuff we promise them is true. Then we get to what rights have been given up by the author. Now, this is kind of a dense paragraph. I'm going to highlight for you some key pieces I want you to notice. We are giving them the exclusive right, okay? So we can't give that right to anybody else anymore. The exclusive right to publish, reproduce, display, and distribute. Okay, so nobody else even has permission to display or distribute this anywhere. In print, electronic, and all other media, whether now known or later developed, by the way, that is actually surprisingly common in publishing agreements. That is also not strictly Elsevier. That, if I signed a contract 10 years ago, I didn't know that my article might eventually be licensed to generative AI companies for training their AI models. But if I agreed to give them these rights in all media now known or later developed, then they already have the right to license it for AI training, and I don't retain that right. So it's kind of something interesting to think about. How am I signing away a possibility that I don't even know exists yet? We're giving them those rights. That's in any form, in all languages throughout the world, including the right to license others to exercise any of these rights. So I am not only letting them do these things, I'm telling them you're perfectly allowed to let other people do these things, and you can sure as heck bet they're going to make money off of that as like a second point of profit, right? They're going to make money selling my work in their journal, and they're going to try to make money selling it to other people to do other things with. So, lot to unpack in here. The last little phrase I wanted to highlight here is and to prepare derivative works. Derivative works is kind of copyright law language. Um, if you have a book, I'm going to use Pride and Prejudice by Jane Austen. Jane Austen wrote Pride and Prejudice. She had the rights to that. A derivative work is when someone writes Pride and Prejudice and zombies. Now, Jane Austen's work is out from under copyright, so someone can prepare that lovely zombie-themed derivative work without any permission. But when a book is still copyrighted, someone would need permission to say, I want to create a new work that is obviously very heavily based on this, but then includes some new elements or changes like zombies. So we are also giving Elsevier the right to prepare derivative works based on our article. What would that look like? What are they gonna create that is heavily based on my work, but different than my work? It is not clear from the contract what they might come up with that would meet that. So that one always kind of makes me a little nervous. All right, and then the third section here, what rights do we retain as the author after we've signed away all of these other exclusive rights? We're allowed to make copies to promote companies or products we own, okay? Which for a lot of academic researchers, you may not own a company or product, so that may not even be relevant. You have the rights to include in a thesis or dissertation. This one is important for graduate students who are publishing, who want to do the article model dissertation, where they publish 3 or 4 articles and then like combine those together as the dissertation. That's a really important one to know. You reserve the right to do that with your published article. You're allowed to extend that article into like a full-length book, include in a compilation of your work. So, someday somebody wants to publish a book of all the articles you wrote or something. And then you are allowed to reuse portions, excerpts, figures, tables, and images in your own new works. So that's also really important. If I end up writing a follow-up article that is closely related to and building on my paper, I maybe want to be able to reference a figure from the previous paper, maybe doing some longitudinal comparisons of here was the data last time, here's the new data, whatever. So it's important to know that I have that free. You do retain the right to create translations as long as they are for non-commercial scholarly collaboration and sharing. This one I feel like is a backhanded compliment kind of situation. Oh yeah, you can translate your work as long as it's not for an additional publication or profit-making reason, because they want the right to translate it for profit. So you can only do it if it's like, hey, I have a collaborator in Russia who wants to be able to read this paper to use it. I'll translate it from English to Russian for them and send it to them just for their scholarly personal use. You retain some rights to publicly share your preprint and your accepted manuscript with criteria applying. So what we mean by the preprints and accepted manuscripts, our paper goes through different versions, right? From the first draft we write all the way to the final page in the journal. And we may be allowed or prohibited from doing things with each of those versions. Your preprint, you can basically think of it as the last Word document that you uploaded as your submission to the journal, saying, please consider this paper. That's your preprint. In many cases, they do not care what you do with that preprint. It has not in any way benefited from the journal engaging with it, so they generally don't care. Your accepted manuscript, this is after you've gone through peer review and revision. You can think of this as the very last Word document that you sent to the editor saying, here it is, it's ready, and they said, cool, we're going to publish it. But they've not yet done copy editing, they've not yet done formatting to make something look like the style of their journal pages. So that one, You can sometimes use in certain ways at certain points in time, but it heavily depends on the publisher, which is why we end up having to really go pay attention to their criteria of how I could use my accepted manuscript. And then they finally tell us we retain all rights to our supplemental materials and research data. So if we provided a bunch of appendices with testing instruments and some additional figures and this and that, we retain all rights to those. We just grant them a non-exclusive right to kind of publish them and then extract, reformat, adapt, build upon. Like, again, I start getting hit by all this stuff going, well, what do they even mean? That they're going to reformat, adapt, and build upon my data and my supplemental material. I don't know what form that might take, so I don't really, really know what I'm agreeing to there. And again, we get that media now known or later developed, and they can permit others to do these things too. So that one's kind of a fun addition there that you retain some rights, but you're also giving them a whole bunch of rights to your supplementals. All right, let's take a look at a different example here. This is Taylor and Francis transfer of copyright. Um, so warranties made by author. They cover those same basics, just the really super obvious, your legal and ethical kind of stuff. They ask you to affirm that you have complied with all mandatory laboratory health and safety procedures. Obviously, that's only going to be relevant in certain disciplines, right? And that your article contains all appropriate warnings concerning specific and particular hazards. Now, I don't personally write in a field that involves hazardous laboratory materials, so I don't necessarily know. Maybe that is already totally standard, and someone in that field would be like, yeah, no big deal. To me, I'm not exactly sure, but we could definitely face some liability if we said that we included all these warnings and then something happened. This is another piece of that liability. Um, if there's any loss, damage, injury, expense, including legal fees, that is awarded against or paid by the publisher as a result of us breaching these warranties. So again, let's think about that hazardous materials. Let's say I failed to include some warning about a hazardous material and someone else reproduced the protocol in my article and was injured or killed, God forbid. Um, if I get sued and I'm found to be liable, I'm found to be responsible for missing that warning, and the publisher has to pay out damages, oh, well, then really I have to pay out all those damages. They're going to hold me um, responsible for that. So that's a good one to be aware of. Again, maybe not a big deal if we're literary analysts working on 18th century Victorian literature. We probably don't expect any of that kind of thing to happen, um, but it's there. We consent to allowing them at their discretion to use our article for marketing and promotion. I suppose technically all journals do that on some level, right? That's how they get subscribers, that's how they get readers. And we agree to provide them, upon request, with access to or copies of any source research data that we used in preparing our article. We consent to share it with the editors, the editorial board, and such other persons as they believe appropriate. Again, I maybe this would be appropriate in some cases. Maybe what they're thinking of is that someone has submitted an accusation of research misconduct against me. Okay, let's say that. Someone reads my article and says that I'm guilty of misconduct. Maybe they want to ask for copies of my source research material to share with the board because they need to do an investigation of whether my data look correct or whether it looks like maybe I fabricated data, something like that. And in that specific context, I'd be like, well, yeah, sure. That seems totally reasonable to give you my data so that I can clear my name of misconduct. The problem for me is that it doesn't specify that that's the context. It's just if they ask for my data, I have to hand it over and they can share it with other people. And that's pretty vague, right? That could cover a lot of different scenarios. All right, what am I giving up to them when they publish this article? I hereby grant all rights of copyright and related rights in all forms, all media, now known or later developed throughout the world, all languages, for the full term of copyright. Um, Keeping in mind the full term of copyright for most stuff that we would publish, right now is going to be your lifetime as the author plus 70 years. So that's quite a long time to give them these rights. What do you get to keep in exchange? What rights do you retain? You get to be identified as the author. Wowee, really? It bothered me that they put this in writing only because it made me wonder about other contracts that don't say this. Does that mean they're not guaranteeing me that right? And that's probably silly. They probably assume that this went without saying. But since I always figure if it's not stated in a legal contract, it probably doesn't apply, it made me nervous that one company felt it necessary to state this, that, oh, I get to be identified as the author of my own work. If I have patents or trademarks connected to the article, I can keep those. I get to post and maintain my paper in its original unrefereed form. That's the preprint. That's my submission before peer review. Again, they don't care what I do with that. After it's been revised from peer review, I can post it under specific rules and criteria and with embargo periods, meaning like a delayed period of time after publication. I can share with my colleagues, share it with my students in my classroom, include it in a dissertation, etc., as long as it's non-commercial. Can't make any money off it. Can't horn in on their profit making. And I can use the article internally to my place of employment. So if my article actually was about Sam Houston student or a processor program at Sam Houston and had implications for us to improve practices or something, I'm allowed to share it and use it within the university. In compilations of my work, expanding into a book, those are pretty standard, as long as I acknowledge the prior publication in the journal, which is reasonable. All right, Wiley. Now I'm throwing this one in as a slight difference. Wiley indicates, I'm trying to remember if I put this on a slide. Yes, okay. Wiley indicates that you have a choice. You can either transfer your copyright to us, or you can sign this exclusive license and keep your copyright. Okay, what does that look like? Author retains copyright and then patent rights, but you grant them an exclusive license, so only they are going to get these permissions, exclusive license of all rights of copyright. How am I keeping copyright and yet giving you exclusive rights of copyright? To me, this is like strange example of words in law that must mean something different than they mean in my head, because to me, you're essentially giving up your copyright. Even if you keep it in name, you're giving them all the privileges. Copyright lawyers often talk about the basket of copyrights, that it's a basket that holds all these different things you can do. So you get to keep the basket, but you gave them all the stuff that was inside the basket, that kind of makes the empty basket not that valuable. So they get to do all of this stuff: print, publish, copy, reproduce, perform, display, create derivatives, sell, rent, create revised editions, et cetera, et cetera, et cetera. They can also exercise their rights for creating databases, training and refining machine learning and AI models, and creating and making available commercial products based on such. So they're going to use your work combined with thousands of other authors to build up tools and platforms that they can then sell additionally. So I think this one is just fascinating, that it's supposed to give you an alternative to giving away your copyright, but It's a little tricksy, which is why we want to be reading it. So the publisher will then kindly license back to you a few non-exclusive rights. So they're going to let you do a few things in exchange, but other people will be also allowed to do some of these. They will allow you to share your submitted and accepted versions, not that final published version. You can share the final published version with your colleagues specifically, as long as you do not charge a fee, and you can use it in your teaching duties. You can use it in oral presentations. Oh, goody, I'm allowed to read my own paper aloud. That's very good to know. And then you can reuse parts of the final published version in other journals or books, as long as the piece of that new journal or book, um, as long as it's half, less than half, sorry, I'm losing my words here. As long as the piece you're copying is less than half. Um, did I somehow manage to raise my own hand in Zoom? I don't even know how I did that. Okay, interesting. Um, okay, apologies, lost my train of thought. So as long as the piece you're using is less than half of the new thing. You can also use your unmodified abstract for a non-commercial purpose. And you can reuse figures, tables, artwork, and selected text up to 250 words, which is really limited, as long as the purpose is non-commercial and has no financial consideration for the author. So we give them almost everything in our basket of copyrights, and they give us back a few like little tiny privileges. Okay, now I want to kind of shift what we're looking at in terms of examples. All of those examples have been um, examples of publishing in like subscription journals. So the assumption is that the only people who can access that published article are those who have access to a subscription. That might be an institutional subscription through their university or a personal subscription, but it's only going to be available through paid routes, right? The other side of the scholarly publishing ecosystem right now are open access journals or open access publications. And so I did want to look at a few examples of those publishing contracts so that we can kind of see where they differ from the subscription model contracts. So this is an example of an open access agreement. You make basically the same warranties that you've been legal and ethical and transparent. That's pretty much basic. You don't have to affirm anything else, just the basic expected stuff. Rights you give up. You allow them to have the first publication right. So they get to be the first people who put it out into the world. And you agree to make the work available under this specific kind of license, this Creative Commons license, which allows other people to copy it, redistribute it, remix it, build new things out of it, etc. So that is a little bit of a right you're giving up, that by putting that license on it, you're agreeing that other people can have rights to do certain things. What do you retain? Well, you retain your copyright, including the right to post the final formatted file, the PDF that actually looks like a journal article. You can then share that to online repositories and other websites because anybody can with that Creative Commons license. As copyright owners, you're free to post any versions of your work anywhere you want. You're also allowed to enter other contracts. So they do not have an exclusive right. They only have the right to publish it first, but then you can enter into other contracts for other people to do things with, to distribute the work. And that's it. That's it. So I hope that that really just, even just visually seeing the number of bullet points helps you see how different an open access license is. Now, there may be other reasons in a given scenario why we don't want to publish open access. Some open access publishing involves fees. In certain fields like mine, it's really easy to find an open journal with no fees, but in some fields, it's nearly impossible to find one that's free. So even though I realize that I would retain more rights, maybe I don't really, I'm not able to pay $3,000 to publish an open access. And that's definitely going to be a consideration beyond um, just the contract, right? Beyond just those rights. All right. So now that we've seen some good representative examples and we kind of have a sense of what pieces are standard, what kinds of pieces we might see that are concerning. Question is, can I negotiate? Let's say I'm fine with 95% of their license, and there's just one bullet point that I can't quite swallow. One detail that I'm like, I really just don't know if I can agree to that, but I'm fine with everything else. Absolutely. We retain the rights to negotiate. Um, I think it's very easy for us to feel powerless as authors. We're not getting paid for our work. If we're in like a faculty position working towards tenure, we feel like we have to publish. We feel like we have this mandate, publish or perish, right? We all know that phrase. It's really easy for us to feel like we're at the publisher's mercy. But I think the reality is you actually, until you sign this, you hold the product. You own the writing. Your writing and the writing of researchers like you is inherently the product that these journals are selling. They can't sell a journal if nobody gives them articles. So you actually have more power up front than you think you do. Um, they can't operate and make profits without us. There are a lot of templates and toolkits out there. I link to some for you in the slides that will help you negotiate these details um, so that you can identify the one specific piece you would like to change. And then one of these toolkits will give you a letter template. This is the letter you send to the publisher where you specify the piece that you would like to either remove or revise. And then you can kind of suggest to them what you would like to see instead. Worst case scenario, they say, no, thank you. We would not like to revise that. And you still then have the choice that you can still then make the choice. Well, okay, I really wanted them to change that, but they won't. I'll go ahead and sign it anyway because I really want to publish it. Or you can say, oh, well, you don't want to change that, I'm going to withdraw my paper because now I've been through peer review, it's been improved. I got it to a point where you accepted it. So I'm pretty sure I can find another journal that will accept it too, who might be more amenable to my negotiations or have a better contract up front. So can you say no? I think I kind of just said that, but absolutely, you can say no. Until you sign, you're not committed. Even if they accepted it and said, we accept this for publication, they don't own it. They don't have any right to publish it until you sign. You can withdraw your paper, regardless of acceptance, if you cannot form a mutually acceptable contract. Once your withdrawal from that journal is confirmed, you may submit it to another journal. So we we know that we're usually asked when we submit an article. They'll often ask us at the beginning, can you say that this is not currently under review anywhere else? Doesn't matter if someone finished reviewing it previously, as long as it's not currently under review anywhere else or currently being published anywhere else. So even if it was accepted, if you formally withdraw it, and your formal withdrawal is confirmed, then you're basically back to square one where you are free to resubmit to another journal and be able to enter into an agreement with them. Okay, so here, kind of wrapping up, I wanted to, as I said, take a step back and think about things we may have already published where we don't really maybe know what we signed in the agreement. If I'm looking back at one of my old articles, it's like, oh, I don't know what their contract said, but I would really like to know now what can I do with this article. There, we need to know like where, when, and what version we can share. Some examples. Maybe I want to share it on the SHSU website. Maybe I own erinowens.com as my personal author website. I want to put it there. Maybe I'm a ResearchGate user and I want to share the full text on ResearchGate for other researchers to read. Sometimes there might be an embargo in a publishing contract. I need to know what that embargo is. How long do I have to wait after publication? Some of these things are transparent in the agreement. Some of them are not fully transparent in the agreement. They're clarified in other publisher policies. But especially if we don't remember what we signed in the agreement, then, we need to clarify all of these things. This tool is one of my favorite things on the whole planet. It's now called the JISC Open Policy Finder. JISC is the name of an organization. It used to be called Sherpa Romeo, which was also a weird name. It went from one weird name to another weird name. But this Open Policy Finder is one of my favorite things. You will search for the name of the journal that you published in, and it's going to tell you all of this information. What can you do with each version of your work, and when and where can you do it? So I've got some screenshots here to show you what this looks like. I looked up this journal. This is the original screen that I get for the journal's policies. The little colored buttons to the left tell me what version of the paper. So my final published version, my accepted version after peer review, or my initial submitted version. And then to the right, I can expand those options to see what I can do with my paper. So when I look at the 2 rows for published version, it says option with associated OA fees. So I know that's only going to apply if I paid them a fee to publish it open access. If I know I didn't pay them a fee, then neither of those rows that mention fees are going to apply to me. I'm going to need to stick with the other 3 rows. Now, if I expand one of those rows, here I have expanded the accepted version, the option with no embargo, and this specific license applied, the CC BY non-commercial license. This is what the detailed pane is going to look like. It's going to tell me, okay, there's no embargo period, so you can do this immediately after publication. You need to use one of these 2 Creative Commons licenses on your paper. And you may share that paper then on a non-commercial website. I'm going to come back to that in a moment because that's really important. Under these conditions. So under the conditions that you acknowledge the fact that this paper was published in this journal, they recommend that you actually link to the published article with the DOI, the Digital Object Identifier number. And then they have a set statement to accompany the deposit. That'll be in their policies for you to copy. It varies by publisher, but it's usually a very straightforward statement that says, this is the accepted version of an article which was published in name of the journal, and then your citation. So let's jump back to that non-commercial website. And the reason I want to emphasize this, in my slides, I mentioned one place we might want to share our article is ResearchGate, right? You need to be aware that ResearchGate is a commercial website. It is a profit-making entity. When we create an account on ResearchGate and upload files, we grant them certain permissions to use our files in various ways for their site to make money. So for a lot of publishers, when we look at these open policies and say, how can I share my published papers? If they say non-commercial website, that usually means you better not be sharing the paper on ResearchGate. And I think that is not at all transparent or clear to a lot of authors that that ResearchGate has profit motives when we share things. Okay, closing thought here. This is a quote from the Authors Guild Fair Contract Initiative. And I thought this quote just made, chef's kiss ending to my thoughts. Basically, they say that they want us as authors to understand what we give away when we sign our contracts, what we get in return, and then to make self-interested judgments about what is fair. You want to sign the agreement. You want to just get on with your writing. But in the long run, it's in your interest to take a deep breath and to stick up for your rights and for those of your fellow authors. Because the more that we as individuals push back and say, I don't believe I should have to give you this particular right. I don't believe that this agreement is fair. The more of us that push back, the more likely the publisher is to just change their default contract and benefit all future authors rather than negotiating these things one-on-one with all of us. So love this statement. This is why I created this presentation. I've got a list of resources here for you. There's a great checklist here, actually, a couple different checklists here for when you are reviewing a publication agreement. You can go through this checklist of things, kind of red flags and green flags to look for to help you make a decision about signing. And then a few other resources that talk about what to look for, what to think about. And then finally, these last couple of bullets, the copyright addendum engine, and then the Spark author addendum. Those are both some of those tools to help you specifically request modifications to your agreement. So an addendum would be an added piece that you put into the contract that would make some sort of revision to the original agreement. And those two tools are absolutely amazing to help you work through that process, get some templates, some language to help you speak to the publisher about an addendum. All right, and with that, I'm going to say thank you and open it up for your questions. You're welcome to use the chat or just unmute because I love hearing voices.
Okay, so I have a question.
Absolutely.
I put a 2-year embargo on my dissertation that I just defended in May.
Okay.
And I mean, I don't remember how long that entire process took from the defending to the time that I assigned the paper for embargo.
Mm-hmm.
So basically, in those 2 years, I can publish however many articles I want from it, right? Okay.
Right. So yeah, you still retain, you get to do whatever you want with it. The university does not want to take your copyright or anything. So in the cases of the theses and dissertations, the embargo is for us to be able to share it publicly on our website. The embargo says that it's limiting what we can do, I guess, is what I mean to say. It says that we cannot share your dissertation publicly for those 2 years so that you have a window of opportunity to publish it without it having been seen before, I guess. And then after that 2-year embargo is up, it can be released in our digital system and people could find and read the dissertation. You can continue to publish it and do whatever you want with it.
Okay, just making sure because
Yeah.
I'm like, I want to submit something and then not fully understand what the paperwork meant.
Absolutely. Yeah,
Okay,
in that case with the dissertation, the embargo is just there to protect you and to limit what the university when the university can do anything, but it doesn't limit you at all in that specific case. So,
okay, great. Thank you.
yeah. Any other questions?
Erin, thank you so much for this. Karina and I are paper together, so we may be contacting you.
Excellent. Well, that is always my plea at the end of these sessions is please do not hesitate to reach out to me at any time in the future. If I can be of any help with publishing or any sort of broad range of topics surrounding that.
Thank you. Thank you.
All right. Well, thank you all so much for coming. I really appreciate you being my guinea pigs while I presented this topic for the first time, and I hope you have a fabulous rest of your day.